Alright, I took all the statements that Rosalind Parker made, first on the 9/11 call, then she emailed a supervisor at the library, then she wrote a police statement, I think on that day, and then I did ask her on the stand why she waited till the 25th, and she said the first one was lost by the police. So then she writes one on the 25th. So I didn't see the first one that was lost by the police. I don't have that one. Then she did an interview about the 27th in the police room, and then trial. So I put those into ChatGPT and asked what changed over time in her testimony. And I'm gonna specifically ask, how would a judge view this? I asked that as a second question. I asked what were the changes, then I asked how would a judge view it. So I'm just gonna read off what ChatGPT said. It's quite a bit. A judge would likely view Rosalind Parker's escalation of the description of the situation from merely weird to hostile, with significant concern for its potential impact on the fairness of the trial. This shift in her narrative could raise questions about her credibility and whether her later statements were influenced by the pressures of the investigation, outside factors, or even suggestions from law enforcement, or, I'll add, Prosecutor Cloyd Benjamin. Here are a few key points that could be significant for a judge and could also be used to impeach her testimony, because I asked about impeaching her. Consistency of testimony. Inconsistencies. The judge would likely be interested in the consistency of Parker's statement over time. In her initial police call and written statements, Parker describes the patron's behavior as weird or strange, but does not convey a sense of immediate danger or hostility. However, in later statements, particularly in the police room interview, she escalates the situation to imply fear of violence, mentioning bombs or shootings. Significance for the judge would be inconsistencies like these can impact how the judge perceives her overall credibility. Escalating the narrative could indicate that Parker is either exaggerating under pressure or is influenced by external factors. A judge would want to ensure that the initial neutral or vague descriptions haven't been colored by hindsight or the investigative process. And let me add, Judge Owsley did not see through that. City judges do not see through it. And I didn't do a good enough job of pointing out the escalation. Kind of it was pointed out at my trial, but I think I could do a better job pointing out that difference. But still, because city judges particularly do not see through this. They are decided in their ways. Exaggeration of fear. Earlier statements. Parker's initial description of the patron in the police call and written statements are relatively measured, focusing on my strange behavior and my refusal to interact normally with staff. Her expression of unease in the call does not rise to the level of fearing for her life. Later statements. In the police room interview, Parker explicitly states that she and her co-worker thought the patron might be carrying a bomb or planning a shooting. This dramatic escalation of fear could be seen as an attempt to justify her actions after the fact, especially if there is no concrete evidence that I acted in a threatening or violent manner. Impeachment potential. The defense, as defendant, could point out that this fear of violence only appears in her later testimony, which might suggest that it was not her genuine perception at the time of the incident. The defense could argue that this is an exaggeration aimed at retroactively justifying the call to the police and the arrest, rather than an accurate reflection of what happened. See, failure to mention critical details in the initial statements. No mention of fear for life initially. During the trial, the defense could argue that in her initial police call, Parker does not mention feeling personally unsafe or fearing violence, bombs, or shootings. If her fear was as extreme as she later claimed, it seems likely she would have expressed it in her first call to the police. Impeachment potential. The defense could impeach her by questioning why this significant detail, fearing a bomb or shooting, was completely absent from her original statement. This can suggest that her later testimony is less reliable because it deviates so much from her initial reaction. Possible influence by law enforcement. Let's see. In the police room interview, the detective discusses the concept of reasonable suspicion and describes how the patron may have been trying to provoke a police response for his YouTube video or YouTube channel. This could have influenced Parker's perception of the patron's actions, causing her to describe them in more hostile or aggressive terms. Impeachment potential. Did I say that? Oh, I see. Okay. So the impeachment potential for that, the defense could argue that Parker's testimony was influenced by law enforcement suggestions, pointing out that her fear escalated after these discussions. This could be seen as a form of coaching or influence, which would undermine the credibility of her statements. Impeaching through cross-examination. The defense could question Parker about why she didn't mention the extreme fear in her initial call or written statements, pointing out that if she had been so scared, she likely would have mentioned it right away. See, I did not ask. I don't recall asking questions like that. The defense could use the police call audio already admitted into evidence to highlight the calm and less emotional tone of her initial reports, contrasting it with her later claims of extreme fear. They could also cross-examine her regarding the nature of her interactions with law enforcement during the investigation to suggest that her story evolved over time due to police influence or prosecutorial influence, or after hearing what the officers expected her to say, kind of like a canine dog. Impact on reasonable suspicion, escalation and arrest. The judge would consider how her exaggerated statements might have influenced the police decision to arrest the defendant. No, that doesn't really have anything to do with it. Escalation and arrest. Let me just read this a second. The defense could argue that the arrest was based on Parker's later exaggerated version of events rather than the weird behavior described in her initial reports. If her later claims of hostility and fear were exaggerated, it could undermine the reasonable suspicion necessary to justify the arrest. That's a nice approach. I would ask that only the testimony on the scene. In fact, the January 25th written statement shouldn't even be admitted. That's influenced. But the statement that was written that was thrown out her call, and then her email to the librarian supervisor, which is dated the 22nd, the day of my arrest. Those would be admittable, but everything else after that is just, it's going to be coached. It sounds more coached. Contradictions in testimony. Written statements versus testimony. The defense could also focus on contradictions between her January 25th written statement and her later statements, especially in her description of the patron's behavior. For example, in the written statement, Parker does not indicate that she feared for her life, whereas in her testimony she mentioned bombs and shootings. Impeachment potential. These contradictions between the written statement and later testimony can be highlighted during cross-examination to suggest that Parker is embellishing her account. Conclusion. A judge would likely be concerned with the escalation in Rosalind Parker's descriptions, particularly because the shift from describing the defendant as acting weird to hostile or dangerous could influence the fairness of the proceedings. If Parker exaggerated key details over time, the defense could effectively impeach her credibility by pointing out inconsistencies, failures to mention critical details in her earlier statements, and the potential influence of law enforcement. These tactics could undermine her reliability as a witness and raise doubts about the legitimacy of the arrest and the prosecution's case. And that's it.